Well, good morning. I want to welcome you to the Washington Legal Foundation's first media briefing program of 2014. I'm Glenn Lammy, Chief Counsel of the Foundation's Legal Studies Division. For those of you not familiar with the Foundation, we are in our 37th year of public interest law, policy, advocacy, and education in the federal and state courts, in the court of public opinion, and any other place where we might have an influence on the ways that rules and regulations and laws affect the free enterprise system. We are pleased to have an excellent panel with us today, so I'll do a brief introduction of the subject and the speakers, and then we'll get started. For the Food and Drug Administration and federal prosecutors involved with regulation of speech on so-called off-label uses of medical products, the ground has been shifting. While once only public interest legal groups like the Washington Legal Foundation were willing to openly question their legal authority, affected individuals and companies are pushing back. And though the risks of criminal conviction and exclusion have long deterred accused businesses from testing the government's theories in court, some individuals with nothing to lose are now doing so. However, despite the Second Circuit's ruling a little over a year ago in Caronia versus United States, and a federal jury's partial acquittal of a CEO in U.S. versus Harkonnen more recently, 2013 ended with another $1 billion settlement for allegedly unlawful off-label promotion. Has the court's decision in Caronia, as well as the outcome of Harkonnen and the increased pressure from regulated companies, had any impact? And if so, how much, is one question that our speakers will address today. It's been WLF's privilege for over 20 years to be a leading advocate in the courtroom and elsewhere on these issues. The WLF cases are synonymous with off-label speech regulation, and we took the lead in briefing and arguing the First Amendment issues in the Caronia case in the Second Circuit. We're equally honored to continue our communications efforts in this critical area today by presenting three speakers who themselves have been precedent setters and path breakers on drug and device promotion matters. I want to do, as I said, a brief introduction. The full bios are on the website for those of you who are joining us online, and in the press release for those of you who are here in person. If you are online and you'd like to ask a question during the program, please email us at interactive@wlf.org, and I will direct the question to the appropriate speaker. Leading off today is Coleen Klasmeier, who heads the law firm Sidley Austin LLP's food, drug, and medical device regulatory practice. Before joining the firm in January 2005, Ms. Klasmeier served as staff attorney and special assistant to the chief counsel of FDA. She was counsel to the Medical Information Working Group in its amicus brief in the U.S. versus Caronia case in the Second Circuit. She's currently teaching a class on food and drug law at the Northwestern University School of Law, and we are honored that she serves as a member of the Legal Policy Advisory Board to the Foundation. My second is Jonathan Diesenhaus, a partner with the law firm Hogan, Lovells, focusing on healthcare fraud and abuse, litigation and counseling, federal and state False Claims Act litigation, and white-collar criminal defense. Prior to joining the firm, Mr. Diesenhaus served as senior trial counsel in the Civil Division of the U.S. Justice Department. From 1998 to 2005, he handled civil fraud and False Claims Act matters. Finishing up today will be Geoffrey Levitt, who's Senior Vice President and Associate General Counsel for Regulatory, Environmental, and Global Supply at Pfizer, where he is responsible for managing global legal support for regulatory, medical, safety, clinical research, manufacturing, and environmental operations. He's a past member of the editorial board of the Food Drug Law Institute and a current member of the editorial board of the FDA Advertising and Promotion Manual. Mr. Levitt is past chairman of the board of the Food and Drug Law Institute and received the Institute's 2009 Distinguished Service and Leadership Award. Coleen, if you could get us started.
Thanks, Glenn. So, Caronia was decided about 13 months ago, early December 2012, and about 9 days after the decision, we started to hear some indication from senior FDA officials about the potential implications of the Second Circuit's decision. Some of the earliest statements were from program personnel within FDA, most notably Dr. Robert Temple, who is the father of the contemporary NDA review process at the Center for Drugs and an extraordinarily influential speaker and thinker about regulatory problems, including the collision course that FDA is on in the off-label arena. And Bob said at an event on December the 11th, 2012, that it would be horrifying if manufacturers could promote uses that have not been established by substantial evidence. He also said that the Second Circuit's decision in Caronia could undermine the drug amendments of 1962, which, quote, would be a nightmare. Steve Nissen from the Cleveland Clinic, who is a frequent and well-known commentator on FDA regulatory and scientific policy matters, also commented at that event to the effect that, quote, to say that this is somehow free speech to be able to off-label market drugs is ludicrous. This is a collection of statements appearing in a trade press article under the headline, Off-Label Rulings Potential Fallout is Terrifying. So you might conclude from those statements that the Caronia decision ushered in an apocalyptic era in which companies would look at the Caronia ruling and Sorrel and its antecedents and decide that it was Katie bar the door for speech about off-label or unsubstantiated uses for approved medical products, but that was absolutely not the case as it happened. Companies have been, to say the least, circumspect in operationalizing the Caronia decision for a variety of reasons. It has to be said that the main reason is the huge disconnect between the development of the doctrine in the courts on the one hand and the way in which prosecutors are making day-to-day decisions about the rightness of company conduct on the other. And one of the pathologies of the current regulatory and enforcement scheme that all of us have been reckoning with for years continues unabated, and that pathology is really the problem that most of the legal issues, very serious legal issues presented by these cases, don't ever get ventilated in a court or indeed any kind of public forum, but rather they're resolved, if at all, in the context of closed-door conversations with prosecutors who often do not bring anything like the more technical and some would say nuanced interpretation of the Food, Drug, and Cosmetic Act that you would hope to get if there were more, for example, FDA lawyer involvement in those conversations. As of February 20th, 2013, the dust had settled a little bit on some of those early reactions from FDA program personnel, and we had our first quasi-official statement from FDA. I say quasi because it did not appear in the Federal Register in the way that a statement post-WLF appeared shortly after the Court of Appeals ruling about a dozen years ago. Instead, there was a press statement issued by the FDA press office in response to inquiries, and in that statement, FDA said basically three things in a long paragraph. The upshot was Caronia will not significantly affect enforcement, point one. Point two, Caronia simply doesn't address whether off-label promotion may be relied on as evidence of intent, and that locution is one that FDA and DOJ use deliberately and advisedly, and is one that, for reasons we can discuss perhaps at a different WLF event, is hotly contested and, in my view, legally wrong. The third point, Caronia acknowledged that the First Amendment does not protect false or misleading speech. So here you have FDA, no doubt in tandem with DOJ, articulating an interpretation of Caronia that dramatically minimizes its impact. There's no acknowledgement in this statement about the doctrinal underpinnings of the Caronia decision itself, no reference back to Sorrel or indeed the Virginia board case and the overturning of Valentine v. Christensen, the fact that for decades manufacturers in FDCA cases, including off-label cases, have been asserting First Amendment defenses with increasing success in the courts. So here you have an attempt to confine Caronia to its narrowest possible factual ground, which is not an entirely indefensible thing to do as a matter of law, but as a matter of reality. That approach had the effect of depriving FDA of a much-needed, meaningful opportunity to consider the broader implications of the First Amendment qua constitutional principle as opposed to the specifics of a particular Court of Appeals case. And in the statement, FDA also said, quote, the decision does not strike down any provision of the FD&C Act or its implementing regulations, nor does it find a conflict between the Act's misbranding provisions and the First Amendment or call into question the validity of the Act's drug approval framework. Subsequently, in August, FDA commented on Caronia again and said the purpose of the subsequent statement was really to address the degree to which, if at all, FDA planned to change its MO in response to Caronia, now that in the fullness of time the agency had had an opportunity further to consider whether any actual program changes were necessitated by the decision. And FDA there said, again, August of 2013, we have no plans to change our advertising and promotion enforcement approach in the wake of Caronia. And the agency reiterated that the decision does not strike down any of the provisions of the statute or its implementing regulations. So this is FDA making fairly clear that not only is the case highly limited, but also that notwithstanding all of the prior decisions and notwithstanding the clear direction of the full body of case law, the agency really had no intention of making any meaningful changes to its regulatory scheme. This is despite the fact that Caronia was not itself, was not the only input into FDA's policy development in the off-label space. As Glenn mentioned, I'm counsel to the Medical Information Working Group, and that group, which is an ad hoc coalition of manufacturers that includes Pfizer, among many other companies, that group had been consistently, since about 2006, engaging with FDA in a very measured way, identifying areas in which the agency would benefit from a sensitive recalibration of the regulatory scheme in view of these developments in the case law. And also, to be fair, in view of the fact that FDA hadn't really, since the 90s, quite gotten it right in terms of aligning its assertions of regulatory authority with what the statute had said, and still says. So the MIWG, among other groups, has really been focused on encouraging the agency both to respect constitutional limitations and to respect statutory limitations. So it was a little bit disappointing that in these August 2013 statements, the agency wasn't seriously reckoning with the fact that Caronia was not a lone data point, that there were really other sources of, I would say, measured, reasonable, thoughtful agitation for FDA to think about ways in which to render the regulatory scheme more contemporary. And you could also identify as a distinct and completely independent rationale for such a reconsideration intervening developments in the policy arena. So it's not just the law that, in my view, effectively compels FDA to rethink its approach in the off-label area. It's really enactment of the Affordable Care Act. The healthcare delivery system has changed in ways both large and small, but mainly large. And if FDA is committed, as it is and should be, to remaining relevant, given the explosion of information sources available to patients, among other developments, it really should think carefully about whether its role as essentially a censor of health information is consistent with what its key stakeholders really want and expect. DOJ, for its part, said similar things to the FDA statements. Prosecutors said things like, Caronia shouldn't create anxiety. Anxiety for who, one might ask, because it doesn't radically change how we see cases. And that's probably fair enough, because the case was very, very limited on its facts, and it was teed up by the government in a way that was quite unusual. DOJ spokespeople went on to say manufacturers should not view Caronia as a green light to engage in conduct that can be in that gray area that may be covered by the law. So on the enforcement side, you have a few comments from federal prosecutors reflecting the view that Caronia was a bit of a yawn. A couple of developments that I want to mention, and then I'll turn it over to Jonathan. On November 7th, 2013, we saw the first statement of interest, at least that I'm aware of, filed by the government in an off-label case in the Sestra Cephalon case. That was in the Southern District of New York. And there you had the government saying that the First Amendment does in no way affect False Claims Act liability of manufacturers, because the False Claims Act is really premised on the submission of a false claim, which is not speech as such. You also had the, I think, well commented on Office of Prescription Drug Promotion at FDA warning letter to Agerian Pharmaceuticals in November of 2013, which reflected this idea that Caronia is just not implicated at all where off-label speech is deemed categorically to be false or misleading. So to the extent anybody was wondering whether FDA would be true to its word and not interpret Caronia as interfering in any way with its ability to advance and act upon an expansive view of its regulatory authority, I think the Agerian letter and the statement of interest reflect the continued sort of collective view on the part of this administration that Caronia is sort of a non-event. A couple of things to watch. Some of you may have heard ongoing public conversation about the CER asymmetry problem, and CER asymmetry problem is just a code for this idea that that manufacturers are unable to talk about comparative effectiveness of their products, which is just a type of data and analysis that differs from the data and analysis that you would ordinarily see in an FDA-approved prescription drug labeling, in that it's comparative and comes from different kinds of data sources than a randomized controlled trial. The First Amendment, if it's going to be ventilated in court in any kind of pharmaceutical case, there's a very, very good possibility it will be in a CER asymmetry case. Because of some of the doctrinal attributes that you saw, particularly in Sorrell, if not Caronia, this idea of viewpoint discrimination and speaker discrimination is very much on the court's mind. And the CER asymmetry problem points that up really clearly, because the idea is that out of all of the different participants in the kind of healthcare information ecosystem, manufacturers are uniquely disabled from commenting on comparative effectiveness issues because the regulatory law precludes them from doing so. And so PCORI, which is the Patient-Centered Outcomes Research Institute created by the ERA recovery legislation a number of years ago and then elaborated on in the ACA, that's a new piece of federal government infrastructure that is going to encourage the dissemination by the government of comparative effectiveness analyses in a way that manufacturers simply cannot, because the FDA rules preclude them from doing so. So one thing to keep in mind is that if rubber is going to meet the road, it's going to be in the CER asymmetry context, and that's where you'll see a very serious, in my view at least, reckoning with the way in which the regulatory scheme conflicts with the First Amendment. Social media guidance, the much ballyhooed, long-awaited social media guidance issued by FDA, in my view, is part and parcel of FDA's prior history of action in sort of keeping the First Amendment largely at arm's length. There are a lot of things that are comment-worthy in that draft guidance, one of which is that it continues to use this concept of promotion, which is not a defined term. The combination of the lack of definition of promotion and the long list of types of communication by manufacturers that are thought by FDA to be encompassed within that concept of promotion and therefore subject to regulation, that plus the way in which the guidance asserts that third-party communications can be subject to regulation as the manufacturer's communication if the manufacturer has any influence whatsoever over the third party. That creates ambiguity in two different dimensions that raises profound due process, ambiguity, vagueness issues. So another thing to watch is really the way in which the due process clause, particularly after the Fox 2 decision, becomes potentially an equally powerful tool or perhaps a more powerful constitutional weapon than the First Amendment in encouraging FDA to recalibrate its approach in this area. Another thing I want to mention, and then I only have one more after that, and then I'll be quiet. The established name draft, revised, the new draft guidance, this is the third one now. We have draft final and now a new draft. It's an in-the-weeds regulatory issue having to do with the way in which manufacturers are required to present the generic names of their products in promotion, and that stuff doesn't matter. The main point is that FDA advanced a very wooden and expansive and pro-regulatory interpretation of a particular rule that's in the Code of Federal Regulations and then dialed it back under the guise of enforcement discretion. That's exactly what we saw the agency do in the social media draft guidance, and it continues this the proliferation of FDA exercises, putative exercises and enforcement discretion, which is really just a way of pushing a very aggressive interpretation of statutory and regulatory authority while depriving manufacturers of the ability to make any kind of particularized or concrete objection, because as a practical matter, there's nothing being regulated, even though the premise of enforcement discretion is that there is something to be enforced. So that's, in my view, a quite dysfunctional way of regulating that raises a lot of practical problems for manufacturers, and in the First Amendment and due process contexts will make it harder for manufacturers really to ripen disputes and will make it more frustrating to have conversations with FDA because the FDA can quite plausibly say, what are you talking about? We're exercising enforcement discretion. That's a form of deregulation. We're giving you relief, even though the underlying premise is that there's this broad statutory and regulatory authority. The last thing I'll mention is potentially a sleeper. Not long ago, FDA issued a guidance document in the dietary supplement area, and in that guidance document, the agency had occasion to talk about intended use, which I mentioned a little bit before. Because it's a dietary supplement guidance, it may have passed unnoticed by folks who follow pharma developments. FDA interprets intended use in that draft guidance in a very alarming way to include submissions to the SEC and statements directed to the Patent and Trademark Office. We haven't seen anything that aggressive on the intended use front since the tobacco wars starting in 1994, where FDA was bound and determined to interpret intended use in the jurisdictional context with extraordinary breadth to include statements that previously had been thought to be outside the scope of FDA's regulatory authority. We're seeing that now again in the dietary supplement context, where it is about a jurisdictional issue, but it has implications for pharma because intended use also determines the uses for which adequate directions are required, which links up with the government's key theory in off-label cases. So in these myriad ways, you're seeing the continuation, if not uptick, in FDA behavior that seems to reflect this unwavering commitment to a regulatory regime and an enforcement approach that denies really the existence or meaningful impact of the First Amendment and also the Due Process Clause. So this issue is not going away. It's probably going to it's going to become more and more worthy of all of our attention because the agency seems completely committed to the position that it's held dear since WLF started this fight many years ago.
Thank you, Colleen.
Morning. So I'm Jonathan Diesenhaus. Excuse me. As Glenn said, I'm at Hogan Lovells now and formerly a Justice Department line attorney. Elevated to senior trial attorney because I got old there. But that was about it. And in the interest of disclosure, and before I launch into my musings, I was a founding member of the Pharma Fraud Task Force, which I participated in the government's development of the False Claims Act theories that sort of opened the floodgates to the rest of these off-label promotion investigations. I was on the team that developed the False Claims Act theory to support the relators in the Neurontin case, which was the first big corporate case of this age of off-label enforcement. And so I have in my past 8 years, had to explain over and over again why we did what we did and how we did it. And I'll only do a little bit of that today. Now I spend a lot more time defending corporations and addressing questions like we've been asked to address today. What effect has Caronia had? Driving in this morning, I got this analogy stuck in my head that I can't get rid of, so I'm going to share it with you, which is that I live in the Rocky Horror Picture Show, and Caronia is the pelvic thrust. It's a little jump for the prosecutors, it's a little jump to the left, and then they just jumped right back to the right. That's what Caronia has done in the context of ongoing investigations and ongoing prosecutions. Coleen offered some of the comments the department has made. What my training was when I was a department lawyer and what we're just seeing reiterated now is we don't go after truthful scientific speech. These are about fraudulent schemes to deprive the agency of the opportunity the law requires to evaluate evidence of safety and effectiveness before a drug is promoted for a purpose in the marketplace. And this is about fraud on consumers, physicians, and others who, when you promote to them, believe that you have that evidence to back you up. That's what the prosecutors say, and then they move on to do what has been done in the past with respect to gray area enforcement. In the anti-kickback context, decades ago now that I'm getting older, the Ninth Circuit offered an interpretation of the anti-kickback statute that was out of sync with government enforcement policy and out of sync with other circuits. And the department simply decided to just keep investigating those cases. If your conduct got close to a kickback and we couldn't get all the way to the specific intent standard, the department prosecutors' views were sort of the Ed Meese theory. You must have done something wrong, so we're going to keep looking and we'll find it. So in that respect, that's what we deal with in the Caronia context now. The department has viewed Caronia. There was about a 2-week period of thoughtful inactivity right after Caronia came down, as folks at the Office of Consumer Protection Litigation, or Consumer Protection Litigation Branch, I guess they're called now, dealt with their client at FDA. This is the only area of law enforcement in the federal government where the criminal prosecutors have a client. They dealt with their client, and they came up with the articulations Coleen has offered of the theory. But that theory is that Caronia is very narrowly tailored to a particular context where a prosecutor elected to pursue a sales rep for speech alone. And when you read the opinion, you can find quotes from the court to say that as the Department on Appeal tried to change the record and argue that the conduct was broader, the Second Circuit kept the argument focused on the fact that what was charged and what the jury was told to rule on and what the prosecutor argued from the evidence was speech alone. The department's just not going to, in their view, they're not making that mistake again, and they don't do that on a routine basis. They look for speech plus, and that plus is for conspiracies and other types of misconduct. To talk about Caronia, you need to understand, in the enforcement context, you need to understand a couple of things, and that is the arc of time from the Neurontin case forward. Caronia is in the middle. When the Neurontin case was investigated, and a sort of a routine way for whistleblowers to file key tam lawsuits was established in the court in the U.S. ex rel. Franklin versus Park Davis, the key tam that went with that case. The FDA enforcement folks, I guess the policy rationale for doing what we did was to get them high-quality intelligence, high-quality corporate intelligence about what was going on and how companies were handling off-label markets, potential off-label markets, prospective off-label markets, how they were thinking about it. Whistleblowers are insiders. And having a key tam remedy for these types of violations, tying it into claims that are submitted for uses that are not approved and therefore, according to the government, not reimbursable in many contexts. And I'm going to avoid that regulatory quagmire, but some off-label uses are not reimbursable. That means a claim for a prescription written for that use is false. That means a whistleblower has a dog in the hunt because the key tam statute only applies when there's a false claim. Having that bounty hunter statute attach and having whistleblowers go to lawyers who would make sealed filings and organize their evidence gave the enforcement side of FDA and gave the Justice Department lawyers who'd been sort of stymied in past prosecutions under the Food, Drug, Cosmetic Act, that gave them new access to a wealth of information and intelligence, and that included me at the time, to see how these schemes organized and how they weren't one-off rogue rep, rogue manager at a medical conference. But in fact, there were schemes afoot to recognize and take advantage of off-label markets, market segments that focused on uses of the drug that hadn't made it through the clearance process for one reason or another. In some cases, FDA had said no. In others, companies had decided to go with the best, strongest data first and worry about expanding the indications in their label later. I'm talking in generalities because of the number of cases I've been involved in. I don't want to give specific examples, so please don't grab on and think that any piece of what I'm saying attaches to any particular case. But that insight and the different lens that fraud prosecutors brought to this environment taught the government, its investigators and its prosecutors, how to think about it differently. Fraud prosecutors, as opposed to looking for particular items, like regulatory attorneys will focus on an advert, on an ad, on a brochure, on a speech. Fraud prosecutors use circumstantial evidence to pile up stacks, eggs in a basket, and have it tip over into conspiracy or into a course of fraudulent dealing. That's what happened as I was leaving the department after Park Davis and we were opening new matters that looked into this. It was the realization that you could connect a lot of dots and get either explicit or implicit endorsement of a scheme to pursue an off-label market from upper management. That shifted the analysis on the enforcement side to an analysis of, is that endorsement alone something you should prosecute from the discretion side, or are you looking for other badges of not just recognizing that there is an off-label market, manufacturing enough of your compound that you can cover the off-label market as well as the on-label demand, but beyond that, seeking to tap into it. And so if you look closely at press releases and descriptions of the cases over time, the Department of Justice does go out of its way to cite pieces of conduct, chunks of conduct that make it different from recognizing physicians will write and we have to have enough drug on hand in order to cover on an off-label demand, and we have to have access to information about our product in these off-label contexts where people are using it in either a safe or an unsafe manner. We have to do it because it's the nature of business category, and then there's the planned scheme development of that market category. And in that category, the government often finds plus factors, and that's what you'll see. I, at Glenn's suggestion, looked back just again this morning at the press releases of the off-label cases since Caronia. Each one of them talks about, in passing, but does talk about alleged kickbacks to get physicians to write prescriptions or talk about off-label uses, write prescriptions for off-label uses or talk about off-label uses. What used to be a kickback case you didn't pursue is today a kickback case you pursue. It involves lunches. It doesn't just involve, like we had in the old days, ski trips to Switzerland and the big sort of 60 minutes worthy types of junkets. Now it involves lunch and learns, types of practices that sales forces used to do routinely, that through the Sunshine Act and other sort of scrutiny of the way of promotion takes place, dinner with wine and a big steak is not acceptable anymore. Well, now that they have to worry about the First Amendment in different ways than they did before, those become allegations of kickbacks. Those become embedded in the fraud scheme description, and that's another way they get around Caronia. These are all steps that we took when I was a prosecutor in response to the original WLF decision. There was a First Amendment concern, and everybody thought their case didn't present First Amendment issues because they had one of these badges, and that has continued. You have discussions about Caronia now, and it may, in fact, give a corporation some sort of discount in terms of measuring litigation risk and reducing the amount of a penalty, reducing the supposed market impact of a scheme so that you value the case from a criminal perspective less. But I haven't seen it bring an end or even more than a thoughtful pause in the investigations that I'm either handling directly or consulting on. because the government views these as scheme cases involving lots of other conduct. Where I see, from an enforcement perspective, there to be a real translation of Caronia is, and we may hear more of this, it is unfortunate from a corporate perspective. It is the case that a guy like Mr. Caronia will not likely be prosecuted for a long time. A sales rep who engages in speech only, and as marketing budgets have contracted, there are fewer steak dinners anyway, but a sales rep whose conduct is limited to speech, off-label, and not directly false. A liar is going to get prosecuted, but someone who is implicitly untruthful will not be prosecuted because Caronia raises very high hurdles. The Second Circuit didn't say false and misleading speech is all that you can prosecute. The Second Circuit said speech alone can't be the actus reus of a crime without regard to truthfulness. So those individuals, like Mr. Caronia, have a real strong defense in that decision, and I don't think the department actually believes it's limited to the Second Circuit. This is a respected bench. This is a respected judge who wrote, and it's pretty tight. The opinion is pretty tight. However, that leaves two other actors in these schemes exposed, at least two other. Corporations for whom collective knowledge and collective action are the risk in these circumstantial cases with piles of evidence being pieced together from different quarters. They're going to have to deal with the fact that things are implicitly false when you don't disclose that you have studies that suggest that that your product is not effective for some off-label use, and you don't disclose those in talking about the off-label use. Corporations are going to get the same treatment that they've been getting, unfortunately, because they're responsible for the actions of everyone. So now you have a business need to police your sales force that goes beyond a corporate integrity agreement or some other punitive regime of monitoring, but is in fact there's a risk that you face that the rep doesn't face. The chill on criminal conduct for the individual that's in the field, unsupervised 99% of the time, that chill is removed. For the corporation, it's still there, and the risk is still great. The other category of actor is the kind of people I had the privilege of representing, which is the three senior executives of Purdue Pharma, who were prosecuted in the Western District of Virginia in one of these off-label promotion cases. They were prosecuted under the responsible corporate officer doctrine. That doctrine holds that if you're this is my interpretation of it, if your seat on the org chart is high enough up when a company, when conduct occurs in the company that is a violation of the Food, Drug, Cosmetic Act, you can be charged with a misdemeanor for failing to act, regardless of whether you knew you had to act. The fact that the offense occurred on your watch is enough under the statute, and a theory endorsed by the Supreme Court, to prosecute those executives. That means that as the world looks for individuals to be held responsible for these large fraud schemes, which is a mantra we hear from the Hill and other quarters across all areas of corporate crime these days, I think the push is unfortunately going to get bigger to push for senior executives to be prosecuted under this strict liability standard because somebody's got to be held accountable, and the reps are now really off limits. And I think that's a dramatic concern that companies face, and that I know makes it very hard to give advice in the space as a regulatory attorney, where the tension is, doesn't the First Amendment allow us to do this? And the answer is, practical reality is the First Amendment allows some of us to do this, but not all of us. I don't want to spill over too much into extra time, but those are my thoughts on where we are and how things are affecting prosecutions right now.
Thank you, Jonathan.
Okay, so let's start by going back to 2012, a little bit before the decision itself, the Caronia decision, which was in December of that year, and thinking about what the landscape looked like during that whole year and the years preceding and the months preceding after the Sorrell decision. I think expectations were high for the Caronia decision, if people remember. There was the rebriefing that the court asked for in the wake of Sorrell. There was the incredible length of time that it seemed to be taking for the court to come out with its decision. And then the decision finally came out. And at least for the first 24 hours, everybody felt sort of vindicated. Okay, there goes prosecution, there goes enforcement against off-label speech. And I'll tell on myself, I was one of those naive people. I was asked a number of times, what's the government going to do? And in my own sort of linear, naive way of thinking, I said, well, they'll have to appeal this. Obviously, they can't live with a decision from the Second Circuit that strikes down, one of the major tenets of government enforcement. Well, obviously, I was wrong. That's why I leave the deep thinking to my colleagues from law firms, and I stick to sort of managing all the stuff and trying to keep sales reps from getting us in trouble. Little did I reckon with the cleverness, if you will, or maybe the survival instinct of the government to say, after a little bit of a period of reflection, no, there's nothing to see here. Move along. This is just a case of bad jury instructions, and it doesn't touch anything that we're doing in any way, shape, or form. So you have a sort of a paradox and an anticlimax in that this is a major decision by a prominent federal appeals court rejecting a fundamental doctrine, we thought, underlying FDA enforcement in the advertising and promotional space. But its practical impact on industry, at least, so far has been limited at best, if it has had at least some effect in limiting prosecutorial strategies, as Jonathan pointed out. So just to recap, why is this so now in the cold light of day? First of all, the holding is actually sort of conservative in a way. It did not overturn any law or regulation used by FDA to regulate promotional speech. It just said, you can't interpret the act this way. Okay, we won't interpret the act this way. Fine. It offers also, as Coleen and others said, no protection against enforcement based on allegations of false or misleading speech, which are all too easy to come up with, or the doctrine of evidence of intent to create a new use, although I agree with Coleen. I think if you really read the case carefully, it does cast a lot of doubt on that doctrine. Plus which, of course, many companies, ourselves included, are under corporate integrity agreements, that impose an additional and separate legal obstacle to any kind of off-label discussion. And then, of course, again, as we've said, FDA, rightly or wrongly, has treated the decision as a non-event and has continued to enforce actively against off-label speech. Now, it would be theoretically possible for a company to set up a sort of Caronia test case by constructing a clearly truthful and well-substantiated message about a medically established off-label use and then getting ready for the government to come after it. But would the government really allow itself to be trapped this way? I'm not so clear. In fact, I think the practice and even some podium statements from government enforcers suggest otherwise, suggest that they will be very selective in going after communications about off-label uses that are medically recognized and beneficial to patients. But that still leaves plenty of potential targets. Now, some say the situation may be different if a company knowingly, quote-unquote, circumvents the FDA approval process by communicating about a use that did not or would not have adequate data to get approved. But what if that company is completely transparent about the quality and quantity of the data supporting the use and makes clear that it's not enough to get approved? We do not have 2 adequate and well-controlled studies to support this use, but we're going to talk about it anyway based on the data that we do have. And then let healthcare professionals and payers judge for themselves, which these sophisticated audiences routinely do anyway. And as Coleen pointed out, this is the way the whole healthcare environment is moving. So the fundamental question to me goes well beyond a standard discussion about off-label or unapproved use. Sure, there may be situations where companies have unapproved uses they would like to talk about, but there are at least as many, if not more, circumstances where the company has other kinds of data or analyses outside of, quote, substantial evidence, 2 adequate and well-controlled clinical studies, other kinds of data or analyses pertaining to approved uses that it wants to talk about, but can't under the current FDA substantial evidence doctrine. Observational studies, meta-analyses, post hoc analyses, comparative analyses, and others are the kinds of information that the agency prohibits manufacturers from talking about to customers or payers outside of a few narrow and poorly defined safe harbors. But the logic of Caronia and Sorrell before it would seem to lead inexorably to the conclusion that truthful and non-misleading speech based on those kinds of studies cannot lawfully be prohibited under the Act either. Again, what we see, at least my own personal observation, is that FDA is moving in the opposite direction. If anything, they are doubling down on their rejection of these other kinds of data. I just sat in a room not far from here at a Sentinel meeting earlier this week and heard senior FDA officials say, we do not trust observational studies to come up with anything useful, for example. So, again, you could say that the practical impact so far of Caronia has been limited, but I think its ultimate effects as the latest in a developing line of cases, again, as the previous speakers talked about, developing line of cases that are challenging the fundamental assumptions underlying FDA's regulation of medical product communication, may turn out to be very significant. You could look at it this way. The structures of FDA regulation of advertising and promotion are still standing, and we're still all living in them. But somewhere down in the ground underneath, the legal bedrock has become unstable. The plates are shifting. And at some point, those surface structures may start to crack and crumble. So that said, what's the pushback? Okay, what's the other side of the equation? Well, for one thing, people have said that one possible outcome of allowing manufacturers more leeway to talk about unapproved uses could be tightening restrictions on doctors' freedom to prescribe medicines outside of their FDA-approved uses. And we may already be seeing the first signs of that trend. So FDA is exploring the so-called special medical use or limited medical use category of drugs with intensified warnings and flags against off-label use based on the agency's perception of risk. Even REMS, to some extent, although it's not specifically aimed at off-label use, signals a degree of intrusiveness into medical practice based on the idea that labeling is not necessarily enough to control risk-benefit in medical practice. But the broader concern that has been expressed about all of these developments boils down to the simple fear that without tight FDA control, we will descend into a Hobbesian state of nature, this terrifying nightmare that Dr. Temple talked about in the wake of the Caronia decision. So in this view of the world, FDA regulation, sure, it may be somewhat stricter than we would like, but it's all that is standing between us and the abyss where ruthless marketers are preying on the weak and the gullible. Now, when people in industry express this fear, which they do more often than you might think, they rarely, if ever, are referring to themselves or their peers, who, of course, would never engage in such behavior, but rather to some unnamed other kind of company out there, presumably one with a smaller market cap, fewer products, and lower standards. Now, at some level, this fear is understandable. The current environment may be restrictive, but it's also relatively predictable and familiar. It's black and white. And it would probably be a lot more work for us and for FDA to keep track of which claims are substantiated and which aren't, which disclosures are adequate and which fall short. But just about every other industry in the United States somehow manages its advertising and promotion through a combination of exactly this kind of self-policing, backed up by a more flexible, shall we say, consumer protection regulatory safety net. Yes, prescription drugs are complicated, and the consequences of prescribers or patients being misled, whether intentionally or not, can be serious. But the argument isn't to deregulate altogether. The argument is to apply a less rigid, more flexible standard that would allow messages about medicines that companies are now flatly prohibited from communicating to be communicated truthfully and responsibly with appropriate substantiation and appropriate disclosures and disclaimers. A situation that would not only be more consistent with First Amendment principles, but might also be more consistent with the current healthcare environment and might also be supportive of public health. So that's what I've got to say, and we can have some questions.
Thank you to the panel. Before we get into questions, I want to see if either Coleen or Jonathan wanted to make any comments on anything that the speakers who came after them had to say.
I just had a couple. One is just to note a case that none of us has had occasion to mention, and I want to make sure it's on people's radar. This is Wilson versus Frito-Lay North America, Northern District of California, October 2013. It's a food case, but highly relevant because it applies the Fox 2 Supreme Court decision, which is a due process Fifth Amendment decision, to FDA statements of policy and warning letters that purported to govern food label statements about the presence or absence of monosodium glutamate, MSG, in food products. And it's not a case in which the government was a party. It was a piece of civil litigation, but nevertheless significant because the court cited Fox 2 in dismissing the plaintiff's misleading labeling claims, saying that the relevant FDA policy statement and warning letters were too isolated and ambiguous to put the defendants on notice that their MSG-related food label claims were inconsistent with FDA's regulatory expectations. So that's one post-Caronia decision that did not cite Caronia, it cited Fox 2, but nevertheless I think relevant again because I think a lot of the musculature of the future case law is going to be derived from due process principles, if not solely First Amendment principles. The other thing I wanted to note, John mentioned DOJ press releases. I cannot not say that, to me, one of the supreme ironies of the current enforcement scheme is that DOJ uses press releases to communicate with the industry about settlements in a way that seems to presuppose the truth of the press releases, and it is another example of asymmetry that afflicts the current enforcement scheme, that the government's press releases are not subject to the same standards of accuracy and truthfulness and non-misleadingness that industries are. And in fact, if you're interested in looking at some of the case law esoterica, we're actually litigating against DOJ under the Data Quality Act in a case on behalf of Scott Harkonnen, where Dr. Harkonnen is on offense suing DOJ for inaccuracies in press releases that DOJ issued about his conviction for having issued a press release with which the government disagreed. So it's a little bit meta, but worth noting maybe that there is this separate skirmishing going on between Dr. Harkonnen and DOJ on the accuracy of DOJ press releases. So don't believe everything you read.
Yeah, and I had two. One is absolutely my reference was not to suggest that they get anything right. It's that they're going out of their way to say there's something beyond speech that made us take this case. And whether it's true or not, well, whenever DOJ says it is alleged, you can't assume it's true. The other thing that the elephant in the room in many prosecutions that I meant to talk about and didn't, and is raised by our discussion of being free to exchange truthful information in all of these categories, which I agree that those categories offer the opportunity to move Caronia forward and maybe get some regulatory relief and some clarification, as opposed to these fraud cases where nobody wants to take the side of the bad guy. But the folks in the field and their managers, the sales organizations in companies, are compensated and rewarded and incentivized to sell more stuff. And that's the conflict of motives in the eyes of the government when you have incentive comp schemes that reward sales. In many of these, in probably 99% of the cases that I look at, you can't segregate out what's an off-label prescription from what's an on-label prescription in the immediacy of reviewing someone for either annual or quarterly compensation. Having incentive, commission sales, in the eyes of the government creates opportunity for fraud, for doing more or less than full and open and honest communication in one-on-one conversations with physicians and others. It's a problem we're all going to have to deal with, is finding are there other models that make you less suspect, other models for compensation that make you less suspect. But the compensation scheme, the motivations for the foot soldiers are a real problem in many of these cases in getting the government past the belief that the company made it happen. And we deal with that every day. And we'll continue to deal with it. You can see from corporate integrity agreements and other disciplinary measures that the government is just trying to rid the industry of incentive compensation to try to deal with some of these pressures. That's not the right answer either, and it's not litigated relief, but it's the elephant in the room. Sorry.
No, it's okay. Jeff, any further thoughts?
I'm good.
I'm going to open up the floor to questions. You'll be handed a microphone for the benefit of our online audience, but it won't amplify your voice. Any questions?
As you discussed CER asymmetry and comparative or observational studies, one thing that came to mind in terms of FDA largely ignoring new opportunities to address exchange of information is FDAMA 114. So I was wondering if you had some thoughts on that.
You want to do it, Jeff, or do you want me to?
Go ahead.
You can stay.
Can I just,
Yeah.
I just can't see her.
No, sorry.
I have a lot of thoughts about 114, and I can send you the articles I've written about it. It's very frustrating because, of course, the premise of 114 is that there was a problem in the pre-1997 regulatory environment that Congress was seeking to solve hand in hand with FDA and industry. And 114, should have made clear that data not satisfying the substantial evidence standard are perfectly appropriate to provide to selected audiences with the relevant expertise in product labeling in certain circumstances. Of course, where the action is and where most of the questions arise, at least in my experience, it is on the question of endpoint. And so, the statutory provision that you're referring to, in my view, is best interpreted to mean that you can make essentially off-label claims in labeling to payers and other managed care organizations as long as those claims are supported by competent, reliable scientific evidence, which is a lower standard than the registration standard of substantial evidence to adequate and well-controlled that Jeff was alluding to. And I think that was a deliberate choice by Congress. Otherwise, it would render the statutory provision a dead letter. But of course, with Bob Temple, again, so influential, so thoughtful, but I just disagree with him. His public comments have eviscerated that interpretation of the statute and meant that people don't feel comfortable relying on it anymore. It doesn't mean that people aren't continuing to think about it and wrestle with it and try to find ways of communicating responsibly, notwithstanding the ambiguity, but it has absolutely not solved the problem. FDA has not promulgated implementing regulations. There's no guidance, and I think legitimate questions exist about whether FDA has the in-house personnel who have bandwidth and, frankly, background adequate to evaluate the competent, reliable standard. And then you have the unanswered policy question on this off-label aspect to it. So it has really not done very much to help ameliorate some of the more vexing consequences of the current promotional regime that we've talked about.
Yeah, if I could just add a word. I think it's an excellent question because I think what 114 is at a meta level is Congress's attempt and recognition of the need to move beyond substantial evidence, at least for certain kinds of claims, and in that case they tried to draw it very narrowly and carefully. And then, of course, the reaction from FDA is, in effect, to nullify that attempt. And I think it, again, illustrates, as we've been talking about, the view of the world from the agency is it is black and white. If we lose the substantial evidence standard, then the end of the world is upon us. There is simply, at present, appears to be no willingness to envision a world in which there is a graduated levels of evidence and where kinds of claims appropriately disclosed and disclaimed could be made. So again, it's a great illustration of the point. Even a statutory provision can still be effectively nullified and ignored because of the worldview at the agency.
Further questions? Rich.
Richard Simp. All of you seem to be in agreement that FDA looks upon Caronia as distinguishable because that was a case where they forgot to try to put in evidence that there was false and misleading speech, and in every other case they'll claim that the speech was false and misleading, and therefore there's no First Amendment defense. And you saw that in the Harkonnen case, that he was not really allowed to raise a First Amendment defense because FDA took the position that there wasn't enough substantial evidence in support of what he had to say. And I'm wondering if there's any cases out there that would support the proposition that the First Amendment does apply to speech that is at least that the speaker believes to be truthful, as I understand Mr. Harkonnen did, and that even if it doesn't meet the adequate, well-controlled study standard, it can be seen as being truthful because perhaps it's more likely than not to be true, even if it is not something that has wide acceptance within the scientific community.
I've been thinking about this, and my colleague Marty Reddish and I have an ongoing dispute about the friendly dispute. I actually think the Alvarez case, the Stolen Valor Act case, is fascinating in its implications for kind of the post-Caronia, post-Sorrell environment. And Alvarez was about a guy who lied in the political sphere about being a Medal of Honor winner, and there was a statute that Congress had enacted prohibiting false claims that someone had received a military honor. And his conviction was overturned by the Supreme Court. And I think one reasonable way of interpreting that decision is that in areas of public conversation that do not lend themselves to one monolithic standard of truth, there has to be room for people to say things that the government might find false. And science is just like politics in that respect, I would submit, and like religion and like art and other forms of human expression. And, Marty's book, most recent book, The Adversary First Amendment, does, I think, a great job of kind of illustrating the democratic principles that undergird an Alvarez-type approach to First Amendment cases. So that's an example. One of the things that I find so interesting about prosecutorial statements about, but these are just fraud cases. Who decides it's a fraud case? I mean, it kind of begs the question. Fraud is lying to somebody to get their stuff. How do you know it's a lie? In science, and FDA encounters this difficulty all the time, something that was true is 20 minutes later not so true. And if you don't have enough breathing room built into your enforcement system and your regulatory system to account for that fact, then you run the risk of the Harkonnen scenario, picking a moment in time at which the government gets the better part of the argument, convicting somebody for taking the minority view, and then ignoring the fact that at some point in the future, the unpopular position may prove to be the correct position. You look at things like the NIH press release describing the results of its AIDS vaccine study, its phase 2 study. That was an untrue set of statements from NIH about the results of its vaccine study. And again, another example of asymmetry, no consequence to that. So, and I'm not saying that there ought to be, no regulation, but we have to be so careful when we're talking about scientific conversation to treat it more like political speech, more like contingent areas of conversation, and less like something that's sort of amenable to one single standard of objective truth.
If I can jump on that too, in thoughtful conversations with my former colleagues outside of the heat of negotiation. And I don't mean this to sound empathetic, but I have some empathy to them. Practicing as a prosecutor in this space is complex. In the fraud section of False Claims Act cases, where they're trying to figure out what a fraud case is, they're looking for the person who lies when they scream fire in a crowded theater. And they have a belief that failure to disclose studies when you're studies that have negative results or not such strong positive results when you're talking about an off-label use, for example. It is more analogous to shouting fire in a crowded theater than claiming that you received a Medal of Honor. The danger to others from actually lying about the safety of or efficacy of a drug is something that they worry about. And finding the right balance on the prosecutor side of identifying the cases that really are like that from a false and misleading perspective as opposed to scientific debate is still something they wrestle with. Unfortunately, when you take 10,000 feet, take the view from outer space of that, what we have is a significant chilling effect that most First Amendment jurisprudence would say is bad, and that ambiguity is bad in this space, and that close calls should weigh in favor of the defendant. Unfortunately, because it's a regulated industry, those close calls aren't going to the defendant as much as they ought to as to whether something's a scientific debate or a lie. But they would say that fire in the crowded theater is more what they're after than a misrepresentation or a misunderstanding of the science. For what it's worth.
Jeff, anything else? Any further questions from the audience? Do we have any online? Just want to ask one parting question. The Medical Information Working Group has filed a citizens petition back in September asking for further guidance from FDA on some specific issues and sort of the broader range of their regulatory approach. And one of the things that Sidley, Austin, and Ropes and Gray focus on is the content and speaker-based nature of FDA's rules that counter-detailers and payers and Richard Samp or me or anybody can go out and talk about off-label uses without any consequences whatsoever. But if it's a manufacturer or representative of that manufacturer, that's not protected speech. Could you talk a little bit about that and whether that sort of an argument would be successful if someone wanted to file a broad-based attack on FDA's regulations under the First Amendment?
Jeff, do you want to do it?
Yeah, I mean, I think it's a great question. I think if you found, this is a little bit of what I was alluding to with the Caronia test case, it's certainly one manifestation of it. And, when Coleen was speaking, I wrote down in big letters CER asymmetry, because I think this is probably potentially the most appealing manifestation of a fact pattern where it would be hard for FDA to defend. I mean, if let's say, for example, major drugstore chain or pharmacy benefit organization, what have you, can come out with analyses that purport to show that a manufacturer's drug is less safe than a competitor, and the manufacturer has observational data, meta-analysis data, and so on to refute that, but they're not allowed to use it because it doesn't meet the substantial evidence standard. I think that's a very appealing fact pattern for a court to take on in terms of perhaps overturning the so-called substantial evidence doctrine. So I think it's something really to watch for.
Elaboration?
I wholeheartedly agree. I mean, that is one way of reading Sorrell. It's a case that doesn't apply kind of the central Hudson algorithm in the mathematical sense. It's really a case that is about the broad principles that inform the entire body of First Amendment commercial speech case law, and one of those foundational principles is that you can't silence one type of speaker at the same time that you're allowing, or in the case of the government, even encouraging or requiring the dissemination of speech by another. And there's a Sixth Circuit case arising in the tobacco context, the Discount City Tobacco case that evaluates First Amendment claims in the context of the Family Smoking Prevention and Tobacco Control Act, which is the 2009 tobacco product-related amendment to the FDCA. And there, the court, in my view, somewhat disappointingly, gives that argument the back of the hand by saying, well, it's fair enough for Congress to identify some categories of speakers that have a history of saying stuff that we thought was misleading. That's just not a good enough answer in view of Sorrell and perhaps more importantly the first principles that really inform the court's commercial speech cases since Virginia board. So I fully agree with Jeff that there's going to be more to come down the pike on this sort of discrimination issue in the First Amendment.
Yeah, I think that one thing that was pointed out as well, I think very effectively in the citizens' petition, is that under the new regime of healthcare in this country, more information is going to be required than ever to make determinations on things. And if people are going to trust the government's perspective or their agent's perspective on uses of drugs and how effective they are and how safe they are versus the free enterprise system's statements on them, then that's obviously very troubling to a group like WLF, which believes that profit motive doesn't necessarily motivate people to do illegal or unethical things, and that because of the system that we have, people are healthier here than they are in other places. And so we're certainly going to continue to hammer away on these issues, and we want to thank our speakers today for coming and joining us for the hour and a half that they were here, and for everyone who's been here in person and online, thank you for joining us as well.
Thank you.
Thank you.